In the spring of 1883, several weeks after a jury had declared her incompetent, Henrietta Wiley climbed into a private carriage with her court-appointed guardian and an unnamed relative. She was 47 years old, a wealthy New York heiress who had spent the previous months defending herself in newspapers across the country. The carriage pulled away from wherever they had collected her. Henrietta asked where they were going. No one answered. The journey continued in silence. When the carriage finally stopped, Henrietta stepped out and found herself standing before an imposing mansion in Flushing, Queens. The building's marble interiors gleamed in the afternoon light. Only then did her guardian explain. This was Sanford Hall, a private asylum for the wealthy. Henrietta would be staying here. She had no say in the matter. The doors closed behind her. This is the story of how a woman's independence became evidence of insanity. How a fortune meant freedom, then became the weapon used to take that freedom away. How a mansion built to inspire awe became a cage with marble walls. Understanding Henrietta Wiley's imprisonment requires understanding the world that allowed it. The story begins not with madness, but with money. Before we uncover how wealth became a weapon against Henrietta Wiley, I'd love to know, where are you watching from? Drop your location in the comments below. And if you're fascinated by forgotten stories of the Gilded Age, subscribe so you don't miss our next journey into history's darker corners. Now, let's begin with a fortune. In the mid-1830s, New York City was a place where fortunes appeared overnight and disappeared just as quickly. Henry Harbeck belonged to the first category. He had built his wealth through shipping, moving goods across oceans at a time when maritime trade was transforming American commerce. The money accumulated steadily. By the time his daughter Henrietta was born in the mid-1830s, Henry Harbeck had amassed what contemporaries called a vast fortune. She was his daughter by his second wife, Louisa. Henrietta had older half-brothers from Henry's first marriage, men who would one day play a role in her destruction. Henry Harbeck died sometime before the late 1870s. The exact date is lost to history. What survived was the inheritance. Henrietta received a life interest in an estate worth over $200,000, along with a substantial annual income. In modern terms, this made her a millionaire several times over. The inheritance was structured carefully. As such things were in the Gilded Age, she could draw income from the estate, she could live on the money, she could spend it as she chose. But the principal remained protected, designated to pass to other heirs eventually. For a woman in the 1870s, this inheritance represented something more valuable than money. It represented her only legal rights. Married women could not own property in their own names. Wives had no claim to their own earnings. A husband controlled everything. But Henrietta's inheritance was hers. As long as she remained unmarried, or if she married under the right legal circumstances, the money stayed under her control. It was the difference between having a life and being someone else's dependent. Henrietta married twice. Both marriages failed. The historical record preserves neither the names of her husbands nor the details of how the marriages ended. What mattered was that by the late 1870s, she was free of both men. She was in her early 40s. She had a substantial fortune. She had a daughter, though the girl's name is also lost. And Henrietta had something few women of her era possessed: independence. She owned an Upper East Side brownstone, one of those elegant 3- or 4-story buildings with high stoops that lifted residents above the street. The brownstone was typical of its era, faced in the reddish-brown sandstone that gave these homes their name. Inside would have been a formal parlor for receiving guests, a more casual back parlor for family, bedrooms on the upper floors, and a kitchen in the lower level. It was a substantial property in a respectable neighborhood. It was hers. Henrietta had money, property, and independence. She also had the audacity to enjoy all three. She spent her money freely. She hosted parties in her brownstone. She drank alcohol, not hidden away in private moments, but openly, as men did in their clubs. She enjoyed the company of younger men. One of them was Charles Van Slyck, a household employee who became something more than an employee. Henrietta was seen publicly with him. She was also seen with a woman described in newspapers as a Spanish girl, the two of them acting in what the New York Tribune would later call a very unbecoming manner. Henrietta had what newspapers described as a prepossessing physical appearance. She was not hiding. She was not ashamed. She was living her life. This was the problem. Wealthy men drank in their clubs every night. They kept mistresses. They gambled. They hosted parties that lasted until dawn. Society expected this behavior from them. It was called being a man of the world. When a wealthy woman did the same thing, society called it something else. It called it evidence of mental disease. Henrietta's half-brothers watched her lifestyle with growing alarm. The money she was spending was money that might eventually come to them. The parties she was hosting were creating gossip. The relationships she was forming were inappropriate for a woman of her station. Charles Van Slyck in particular concerned them. He was young, he was an employee, he had influence over their sister. Something had to be done. In early 1883, Henrietta made a decision that would give her family the opening they needed. She sold the brownstone. The sale of the Upper East Side brownstone alarmed her half-brothers immediately. Why would Henrietta sell valuable Manhattan real estate? The answer, they believed, was obvious. Charles Van Slyck had convinced her to do it. He was manipulating her. He was stealing her fortune piece by piece. They characterized Van Slyck as a violent thief, a man taking advantage of a woman who had clearly lost the capacity to manage her own affairs. Henrietta took the proceeds from the brownstone sale and rented an expensive country mansion outside White Plains, north of the city. The house was large enough for entertaining. She continued hosting parties there, away from the immediate scrutiny of Manhattan society. She continued drinking. She continued her relationship with Van Slyck. To her family, this proved their suspicions. She was wasting money on an extravagant rental instead of investing wisely. She was isolating herself where Van Slyck could control her more completely. She was spiraling into incompetence. To Henrietta, she was simply living her life on her own terms. She had sold one property and rented another. She was spending her own money on her own household. She was entertaining guests she chose to invite. Every decision was hers to make. The law gave her the right to manage her own affairs as she saw fit. But the law also gave her family another option. Shopkeepers in White Plains began noticing Henrietta's purchases. They noted the times of day she appeared in their stores, observed her behavior, remembered whether she seemed intoxicated. Neighbors watched the mansion, counted guests, noted the hours parties continued. Household staff who worked for Henrietta, or who had worked for her and been dismissed, retained every detail about her daily routines, her drinking habits, her relationship with Van Slyck. A case was being built, witness by witness, observation by observation. By early 1883, her half-brothers had seen enough. They petitioned the court. So did her daughter. So did a former boarder. They asked the court to declare Henrietta a habitual drunkard and place her under guardianship. The inquisition began in March of 1883. That was the legal term, inquisition. It was not a criminal prosecution. Henrietta had broken no laws. It was a civil proceeding, initiated by private petition, designed to determine whether she possessed the mental capacity to manage her own affairs. If the jury decided she did not, the court would appoint a guardian to control her property and her life. She would lose every legal right she possessed. American courts conducted these inquisitions regularly in the 19th century. Most of the subjects were men of means, respectable citizens whose drinking or mental condition had rendered them incapable of managing business affairs and family property. 99% of habitual drunkard guardianships involved men. Henrietta's case was extraordinary simply because she was a woman. Women did not need guardianship for incompetence because women already lacked most legal rights. Wives were under their husband's control. Unmarried women were under their father's or brother's authority. Only wealthy widows and spinsters like Henrietta existed in a space where they possessed enough legal capacity that it could be formally stripped away. Court-appointed commissioners conducted the hearing. Attorneys from both sides questioned and cross-examined witnesses in front of a jury who would ultimately decide. Over 30 witnesses testified. The spectacle drew nationwide newspaper coverage. The inquisition of a wealthy, middle-aged heiress with a prepossessing physical appearance was too sensational to ignore. Medical experts testified first. They struggled to agree with each other. Some argued that Henrietta showed clear signs of inebriety, a diseased condition that rendered her incapable of rational decision-making. Others testified that her behavior while perhaps socially inappropriate, did not indicate mental disease. The conflict reflected the inchoate status of alcoholism as a medical diagnosis. Was drinking too much a moral failing, a disease, or simply a lifestyle choice? The medical profession had no consensus. Household staff testified about what they had observed while working in her home. They described bottles of alcohol. They recalled times when Henrietta had appeared intoxicated during the day. They noted her spending habits, the amounts she paid for goods and services, the way she handled her finances. Some painted a picture of a woman out of control. Others suggested simply a woman who spent freely because she could afford to. Shopkeepers and neighbors testified about seeing Henrietta in public. They described incidents where she had seemed drunk. They noted her behavior in stores, the way she spoke, the times of day she appeared. They mentioned the people she was seen with. The New York Tribune reported that Henrietta had been observed accompanied by a Spanish girl and acting in an inappropriate manner. The testimony carried an unmistakable subtext. It was not just that Henrietta drank. It was who she drank with, who she associated with, how she defied the boundaries that were supposed to constrain a wealthy white woman. Henrietta appeared in court. The New York Times noted that she appeared to be in good health and spirits and conducted herself in a ladylike manner. She was coherent. She was composed. She showed no signs of the mental deterioration her family had alleged. If anything, her courtroom appearance undermined their case. She looked and acted like a competent woman. The jury deliberated. They returned their verdict on March 9, 1883. Henrietta Wiley was a habitual drunkard. The court appointed a local attorney to serve as her guardian. Her half-brother William, a banker and insurance executive, took control of the money. The verdict stripped Henrietta of every legal right she had possessed. She could no longer control her property. She could no longer make contracts. She could no longer write a will. She could not choose where to live or how to spend her own money. Everything now required her guardian's approval. The verdict was legal. It followed proper procedure. A jury of her peers had decided. But what happened next revealed the verdict's true purpose. Stripping Henrietta's legal rights was not enough. Within weeks, the court-appointed guardian would take her freedom as well. The mansion Henrietta arrived at that day in 1883 had been built nearly 50 years earlier with very different intentions. In 1836, Nathan Sanford commissioned the construction of an imposing residence in Flushing, Queens. Sanford was a major figure in New York politics, having served as a United States Attorney, State Assemblyman, State Senator, and eventually United States Senator. He wanted a home that reflected his status. The mansion he built occupied a huge tract of land stretching from what was then Parsons Avenue on the east to Jamaica Avenue on the west. The building itself was grand, constructed to impress visitors with its scale and finish. The most striking feature was the interior. Sanford had surfaces throughout the mansion covered with imported marble. Walls, floors, and decorative elements gleamed with stone that had been selected for beauty and durability. The marble would outlast Sanford by many decades. He died in October of 1838. A few weeks before his 61st birthday, the property passed through several hands before being acquired by the MacDonald family. Doctors John and James MacDonald saw opportunity in the mansion. Flushing was far enough from Manhattan to provide seclusion, but close enough to be accessible by carriage or rail. The building was large enough to house multiple residents. The grounds were extensive enough to allow patients to walk without leaving the property. In 1845, the MacDonalds converted Sanford's mansion into a private mental asylum for the wealthy. Dr. James MacDonald served as the resident physician. His brother, General Allen MacDonald, handled security and managed the grounds. The asylum they created specialized in treating what 19th century medicine called inebriety and mental disease. These were vague categories that encompassed everything from severe mental illness to problematic drinking to behavior that simply violated social norms. The asylum accepted a maximum of 36 patients. Rates ranged from $25 to $50 per week, astronomical sums that ensured only the wealthy could afford treatment at Sanford Hall. The business model was straightforward. Families paid to have troublesome or embarrassing relatives confined in comfortable surroundings far from public view. The patients received treatment that primarily consisted of isolation from the people and substances thought to be causing their problems. For alcoholics, this meant complete separation from alcohol and from anyone who might supply it. For others, it meant removal from environments that families believed were contributing to mental instability. The asylum profited as long as patients remained confined. Successful treatment was defined not by cure, but by continued residence. Dr. James MacDonald died suddenly in 1849. His widow and General MacDonald continued operating the facility. Over the following decades, several physicians served as resident doctors. By the early 1880s, Dr. Josiah W. Barstow had taken charge of Sanford Hall. Barstow was a respected psychiatrist who specialized in treating inebriety. He had developed a clear philosophy about what these patients needed. They required constant physical restraint from indulgence in alcoholic drinks. Their diseased condition could only be treated through incarceration that prevented access to alcohol and to anyone who might provide it. Voluntary treatment was impossible because the disease destroyed the patient's judgment and willpower. Only forced confinement could work. The mansion's original beauty remained. The marble surfaces still gleamed. The grounds were still extensive and carefully maintained. Patients could walk the wooded paths. They could take carriage rides beyond the property boundaries, though always supervised. The building felt less like a prison than like an expensive estate, but the marble walls were thick, the doors were locked, the windows were secured, and everyone inside understood that leaving required permission that would not be granted. This was the mansion that would hold Henrietta Wiley for nearly 2 years. The marble walls were thick. No one outside could hear her. Several weeks after the jury's verdict, Henrietta's guardian arrived with a private carriage. An unnamed relative accompanied them. Henrietta had no warning about what was planned. The guardian told her they were going somewhere, but offered no details about the destination. She asked questions. The answers were vague or non-existent. The carriage traveled north from Manhattan toward Queens. Henrietta had no reason to suspect what was coming. She had been found incompetent, but she had not been convicted of any crime. She was living under guardianship, but she had not been informed that this would include confinement. Years later, in an 1886 newspaper interview, Henrietta described that day. The guardian and relative had spirited her away in the private carriage without telling her where they were taking her. The journey was silent. When the carriage finally stopped at Sanford Hall and they explained that she would be staying there, Henrietta understood immediately what had happened. Her family had not simply wanted control of her money. They wanted her gone. She had no legal recourse. The guardianship stripped her right to refuse. She could not hire her own attorney. She could not file her own legal motions. She could not simply leave. The guardian had full authority to make decisions about where she lived and what treatment she received. If the guardian believed she needed confinement in a mental asylum, that decision was final. Henrietta could protest. She could insist she was competent. She could demand to be released. None of it mattered. The doors of Sanford Hall closed behind her anyway. Dr. Barstow met her on arrival. He explained the rules. She would be allowed to walk the grounds. She could take supervised carriage rides. She would receive comfortable accommodations and decent food. But she could not leave. She could not contact her friends. She could not hire an attorney to challenge the commitment. She was in his care now. The treatment would continue until he determined she was cured. Henrietta was assigned a room. The marble halls echoed as she walked to it. The doors closed. The first day became the first night. The first night became the first week. 18 months stretched ahead of her, though she had no way of knowing how long her confinement would last. 18 months is not a long time unless you are counting it from inside. Dr. Barstow's treatment philosophy shaped Henrietta's daily existence. He believed that inebriety was a diseased condition requiring constant physical restraint. The patient could not be trusted to make decisions about treatment because the disease had destroyed their judgment. Only through incarceration that prevented all access to alcohol could the condition be addressed. Voluntary treatment was worthless. Forced confinement was the only option. Every morning, Henrietta woke in her room. She could walk the wooded grounds of the estate. The property was extensive, and the walks might have been pleasant under different circumstances. She could take brief carriage rides outside Sanford Hall's boundaries, though always with supervision and always with the understanding that any attempt to escape would be prevented. The scenery changed with the seasons. Spring gave way to summer. summer to fall, fall to winter. The trees that lined the walking paths lost their leaves and grew them back. Time passed in the rhythm of days that were identical except for the weather. She was completely isolated from everyone she had known. Her friends had no idea where she was. They knew she had been declared incompetent. But the commitment to Sanford Hall had been arranged quietly. No newspaper announcements marked her arrival at the asylum. Her guardian controlled all communication. Letters could not be sent without permission. Visitors could not arrive without approval. Henrietta was cut off from the outside world as thoroughly as if she had died. She could not hire her own attorney. The guardianship prevented her from entering into contracts, and retaining legal representation was a contract. Even if she had somehow managed to contact a lawyer, she had no money to pay for services. Her half-brother William controlled the estate. Every dollar she spent required his approval. He was not going to approve funds for a lawyer who would challenge the guardianship that gave him control. The asylum housed other patients, up to 36 at any given time. Some were men of means who had drunk themselves into incompetence. Others were women like Henrietta, wealthy individuals whose families found them inconvenient or embarrassing. A few had genuine mental illnesses that required institutional care. Most were simply people whose behavior violated the expectations of Gilded Age respectability. They lived together in Sanford Hall, occupying separate rooms, crossing paths in common areas, speaking little about why they were there. Henrietta paid for her own imprisonment. The guardianship allowed William to control the money, but the money came from her estate. Every week, $25 to $50 was withdrawn to cover the costs of her care at Sanford Hall. Over 18 months, thousands of dollars flowed from her inheritance to Dr. Barstow. She was financing the cage that held her. The nurses at Sanford Hall rotated shifts. They were women mostly, employed to monitor patients and assist with daily needs. They served meals. They supervised walks. They ensured no one attempted to leave without authorization. Most were professional and distant. They had seen many patients come and go. Henrietta was simply another case. But one nurse, whose name has not survived in the historical record, began to see Henrietta differently. Perhaps she recognized that this patient was not mentally ill. Perhaps she simply felt sympathy. Whatever the reason, this nurse would eventually become Henrietta's only hope. The first month passed, then the third month, then the sixth month. Every day brought the same routine. Every day showed the same faces. Every day the marble walls reflected the same light. Henrietta understood that without outside intervention she would never leave. Dr. Barstow had no incentive to declare her cured. As long as she remained at Sanford Hall, the weekly payments continued. Her confinement was profitable. The treatment would last as long as the money flowed. After 18 months, Henrietta convinced one of the nurses to carry a message. It was addressed to Eliza Eaton. Eliza Eaton received a message from Sanford Hall. She acted immediately. Henrietta's friend knew that something had gone wrong. Her companion had disappeared from society 18 months earlier. No one knew where she had gone. Rumors circulated, but information was scarce. The smuggled message explained everything. Henrietta was imprisoned in an asylum. She needed help. Eliza retained an attorney who specialized in helping wrongfully committed people. This lawyer had freed other residents of Sanford Hall before. He knew the legal strategies. He understood how guardianship cases worked. He filed motions immediately. The legal effort to free Henrietta included multiple habeas corpus cases that demanded the court explain why she was being held against her will. Newspaper coverage shifted. When the trial had occurred in March of 1883, papers had treated the case as scandal. A wealthy widow drinking too much, spending too freely, associating with inappropriate people. The verdict had seemed reasonable to some observers. She needed protection from herself. Now, 18 months later, the papers cast her differently. Henrietta became a wrongfully committed woman, trapped by family members who wanted her money. She was brought to court several times. Each habeas corpus hearing gave her a chance to present her case before a judge. She appeared in court. She testified. She spoke clearly and coherently. She insisted she was capable of managing her own affairs. She did not want to be a prisoner against her will. On August 28, 1884, a Brooklyn Eagle reporter was present at one of these hearings. Henrietta told him directly that she was able to care for herself. She did not belong in an asylum. The judges sent her back to Sanford Hall each time. The guardianship remained in effect. The commitment order stood. Legal motions alone could not free her. Henrietta accused the asylum of conspiring to keep her confined. She told the Brooklyn Eagle reporter that once her legal proceedings began, Dr. Barstow had ordered that she and the other patients be prevented from reading newspapers. Information about her case might encourage her to resist or might provide her with arguments to use in court. Keeping her ignorant kept her under control. She also accused the asylum of more direct sabotage. Before court appearances, she claimed staff would drug her lemonade with alcohol. The idea was simple. If she appeared in court smelling of alcohol or showing signs of intoxication, it would prove she was still diseased. It would demonstrate that Dr. Barstow's concerns were justified. The judges would send her back. Henrietta had no way to prevent this. She was at the asylum's mercy before every hearing. Her most damning accusation went directly to motive. "They will keep you in so long as you can be paid for," she told the reporter, "whether you are sane or not." She understood the financial arrangement perfectly. Dr. Barstow received $25 to $50 per week for her care. William controlled the estate and had no reason to challenge the expenditure. The longer Henrietta remained confined, the more money flowed from her inheritance to the asylum. Everyone profited from her imprisonment except Henrietta herself. The habeas corpus cases continued into late 1884. The attorney filed motions. The judges held hearings. Henrietta appeared in court and insisted on her competence. Each time, the same result. The guardianship would not be lifted. The commitment would not be reversed. The system that had trapped her would not release her. Then a new judge took over the case. The new judge ruled that Henrietta should be given a chance to prove her recovery. She would be released from Sanford Hall to a comfortable dwelling outside the asylum. If she could demonstrate that she was capable of managing her daily affairs, perhaps the guardianship could be reconsidered. It was not freedom, but it was something. After nearly 2 years of confinement, Henrietta left Sanford Hall in late 1884 or early 1885. She was released. She was not free. The guardianship remained in effect. Henrietta still could not control her property. She still could not make contracts or write a will. She still could not make decisions about her life without her guardian's approval. The court had ordered that she be allowed to choose her own residence, a small concession that would at least give her some control over where she lived. Her guardian refused to honor the order. Instead of allowing Henrietta to select comfortable lodgings appropriate for a woman of her means, the guardian placed her in accommodations that cost half what she could afford. The decision had obvious financial motivation. Cheaper housing meant more money remained in the estate. William still controlled the money. The guardian still made the decisions. Henrietta had been released from the marble walls of Sanford Hall, only to find herself imprisoned by the legal walls of guardianship. The guardian soon moved to sell some of Henrietta's valuables. He claimed the sale was necessary to pay her bills. The jewelry and other possessions would be liquidated, and the proceeds would go towards supporting her in the housing he had selected. This required a court hearing because selling estate assets needed judicial approval. Henrietta attended the hearing. When the guardian explained his intention to sell her diamonds and other valuables, Henrietta jumped to her feet. "You shan't sell my diamonds!" she shouted. "You shan't rob me again!" The outburst disrupted the courtroom. She was removed. The hearing continued without her. Whether the guardian succeeded in selling her possessions is not recorded. What is recorded is that Henrietta remained trapped in a legal arrangement that gave her no control over the life she had once managed independently. Henrietta left Sanford Hall in late 1884. The fight to escape guardianship was just beginning. In the years following her release, Henrietta continued trying to break free. The newspaper coverage that had briefly cast her as a wrongfully committed woman waned. Reporters moved on to other scandals. The public forgot about the heiress who had been imprisoned for drinking and spending too freely. Henrietta dropped from view. The historical record offers no details about how she lived during these years. Whether she succeeded in escaping guardianship is unknown. Whether she ever regained control of her property is unrecorded. She simply vanished from public attention. Then, sometime in the 1890s, she reappeared briefly. Newspapers reported her death. Henrietta Wiley had died from carbolic acid poisoning after drinking whiskey from a tainted bottle. The reports were brief, no details about the circumstances, no explanation of how the whiskey came to be contaminated, no investigation into whether this was accident or suicide. Just the bare facts. She was dead. The cause was carbolic acid. Carbolic acid was a common household substance in the 1890s. It had been used as an antiseptic since the 1860s, and by the late 19th century, it was easily obtainable from any shopkeeper who sold household goods. The substance was a sweet-smelling, clear liquid that could be used for disinfection and cleaning. It was also poisonous. Deaths from carbolic acid had become common enough that medical authorities tracked them carefully. Between 1887 and 1891, England and Wales recorded 375 deaths from carbolic acid ingestion. 138 were accidental. 236 were suicides. Only one was murder. For women particularly, carbolic acid had become a popular method of ending their lives. It was accessible. It required no special knowledge to obtain or use. A woman who wanted to die could purchase carbolic acid without arousing suspicion because the substance had legitimate household purposes. The death it caused was painful and could take 12 hours or more, but for someone who had decided to die, the availability made it practical. Henrietta's death involved carbolic acid in whiskey. Whether she drank the contaminated whiskey knowing it was poisoned or whether the contamination was accidental cannot be determined from the surviving reports. The newspapers that covered her death did not investigate. They simply noted the tragic circumstances. The woman who had once been declared a habitual drunkard for consuming alcohol died from consuming alcohol that contained poison. The irony was complete. Henrietta had been stripped of her rights for drinking. She had been imprisoned in an asylum for drinking. She had fought for years to escape the legal control imposed on her because of drinking. She died because she drank from a tainted bottle. Whether this was accident, suicide, or something else, the historical record does not reveal. What is certain is that the substance she had been punished for consuming became the instrument of her death. Henrietta Wiley died in the 1890s. The buildings that defined her life would outlast her, but not by much. The Upper East Side brownstone Henrietta sold in 1883 left no trace in the historical record. The property changed hands. Perhaps it was demolished to make way for a larger building. Perhaps it was extensively renovated and absorbed into the wave of development that transformed the Upper East Side in the early 20th century. Brownstones were falling out of fashion by the 1900s, derided as dark and gloomy compared to the newer apartment buildings and limestone mansions that wealthy New Yorkers preferred. Many were torn down. Others were converted into multiple apartments or rooming houses. Henrietta's brownstone suffered one of these fates, but the specific address is not preserved. It simply disappeared into the architectural churn of Manhattan real estate. The White Plains mansion she rented never belonged to her. It was simply an expensive rental that had given her family ammunition for their accusations of financial incompetence. She had spent substantial sums on housing she did not own, they argued, proof that she could not manage money properly. After her commitment to Sanford Hall, the rental arrangement presumably ended. The mansion passed to other tenants. No record identifies which property it was or what became of it. Sanford Hall survived longer. Dr. Barstow continued operating the asylum into the 1890s and possibly into the early 1900s. The facility maintained its reputation as a place where wealthy families could confine troublesome relatives in comfortable surroundings. The marble interiors remained elegant. The grounds remained extensive. The weekly rates remained high. Patients continued arriving and occasionally leaving. The asylum functioned as it always had, accepting money to house people whose families wanted them gone. In 1903, the property was sold. Real estate developers George Appleton and W.B. Richardson purchased 10 acres of the wooded Flushing land. They saw opportunity in the location. Flushing was accessible from Manhattan, but far enough away to offer suburban charm. The property was large enough to accommodate substantial houses. Wealthy buyers were looking for neighborhoods like this. The developers cleared much of the woodland. They cut through streets, naming them after plants in homage to Flushing's history as a center for plant nurseries. Streets called Cherry, Elm, Oak, and Maple appeared where there had once been only paths through the woods. They named the development Waldheim, German for wood's home. The name was meant to evoke both the natural setting and the European aesthetic that appealed to prosperous Americans. Sanford Hall was demolished to make way for the development. The imposing mansion with its marble interiors was torn down. The stone was probably salvaged for other uses. The land was subdivided into lots. Houses began rising where the asylum had stood. The developers built luxury housing that attracted wealthy residents. The founder of Buster Brown Shoes lived in Waldheim. Members of the Hellman family, who had made their fortune from mayonnaise, owned property there. The Steinway piano manufacturing family had connections to the neighborhood. Appleton and Richardson themselves lived among their creation. Waldheim thrived as an upper-middle-class enclave through the early 20th century. The name fell from favor during World War I, when anti-German sentiment made German place names politically uncomfortable. But the neighborhood remained. The houses that replaced Sanford Hall still stand. The streets that were cut through the asylum's wooded grounds still carry traffic. Nothing marks the location of the mansion where Henrietta Wiley spent 18 months imprisoned. Nothing identifies the spot where the marble walls once stood. The neighborhood has no idea of the history beneath it. The mansion where Henrietta Wiley spent 2 years imprisoned was gone by 1903. The story disappeared with it. But the legal mechanism that imprisoned her never changed. Guardianship laws remained on the books. Courts continued stripping adults of their rights. The system simply found new victims. For over a century, no one connected the pattern. Then, in 2021, another wealthy woman stood before a judge. Britney Spears had been under conservatorship since 2008. The arrangement gave her father control over her finances, her career decisions, and significant aspects of her personal life. For 13 years, one of the most successful entertainers in the world could not make basic choices without permission. In June of 2021, she appeared in court and gave a passionate statement. She wanted her life back. She wanted control of her own money. She wanted to make her own decisions. The conservatorship, she argued, was abusive and unnecessary. In November of 2021, a judge finally agreed. Britney Spears was freed. The case drew massive attention. Fans organized under the hashtag #FreeBritney. Media coverage examined how conservatorship law allowed such extensive control over a functional adult. Legal experts questioned whether the protections designed for vulnerable people had instead become tools for exploitation. But Britney Spears was a celebrity with millions of fans and extensive media coverage. Most people trapped in guardianship arrangements have. Neither. Wendy Williams, a radio and television personality who hosted The Wendy Williams Show for 13 seasons, is currently living under guardianship. After taking a leave of absence in 2022 for health reasons that included alcohol consumption, she was placed under the control of a court-appointed guardian. She was subsequently diagnosed with dementia and aphasia and moved into a secured memory care unit of a luxury assisted living facility in New York City. According to reports, she cannot receive visitors, including members of her own family. She can only make outgoing calls, not receive them. She is allowed to leave the facility twice per month with permission. In February of 2025, Wendy Williams spoke by telephone with TMZ founder Harvey Levin in an interview filmed through a fifth-floor window of the facility. She described living like a prisoner. She wanted to leave. She wanted to see her family. She insisted she was capable of making her own decisions. The guardian controlling her life disagreed. A medical examination in August of 2025 upheld the dementia diagnosis and the guardianship arrangement. But shortly after that examination, Wendy was photographed out to dinner with friends, interacting normally and appearing coherent. The contradiction raised questions similar to those asked about Henrietta Wiley. Is she genuinely incapable? Or is she imprisoned by a system that profits from her confinement? The parallels are striking. Both women were wealthy. Both were independent. Both lived their lives in ways that violated expectations for women of their era. Both were declared mentally unfit by legal processes that stripped them of all rights. Both ended up confined in facilities where they could not hire their own attorneys, could not control their own money, and could not choose when to leave. Both cases involved family dynamics and competing interests in substantial estates. An estimated 2 million Americans are currently living under guardianship or conservatorship. Most are elderly or have developmental disabilities. Once a court declares someone incapacitated, that person loses the right to make their own decisions about housing, medical treatment, finances, and basic life choices. A guardian assumes control. The arrangement is supposed to protect vulnerable adults who cannot care for themselves. But the system remains susceptible to abuse. Family members petition for guardianship to gain control of estates. Professional guardians build businesses managing multiple wards and collecting fees from their assets. Once guardianship is imposed, escaping it is nearly impossible. There is no national database tracking guardianship cases. No systematic oversight ensures guardians are acting in their ward's best interests. Due process protections are minimal. Many people placed under guardianship never receive notice of the proceedings against them until after a judge has already decided. They appear in court, as Henrietta did, only to be told their fate has been determined. Less restrictive alternatives exist, but are rarely considered. The system defaults to stripping rights rather than providing support that preserves autonomy. Legal reforms are proposed regularly. Advocates push for stronger due process requirements, better oversight of guardians, and mandatory consideration of less restrictive alternatives. Progress is slow. The system that put Henrietta Wiley behind marble walls in 1883 is still putting Wendy Williams behind locked doors in 2025. The mechanisms have been modernized. The facilities are called memory care units instead of asylums, but the fundamental dynamic remains. Legal processes strip independence. Guardians control lives and estates. Courts defer to medical diagnoses that may be questionable. And the victims, like Henrietta, like Wendy, insist they are competent, even as the system declares them incapable. The story of Henrietta Wiley was forgotten for over a century. Historian David Korostyshevsky rediscovered it in 2025 and published his findings in an academic article that immediately drew attention. The parallels with modern conservatorship abuse were too obvious to ignore. The hashtag #FreeWendy echoed the legal battles Eliza Eaton had fought for Henrietta. The marble walls of Sanford Hall are gone. The system endures. Henrietta Wiley wanted to spend her inheritance as she chose. She wanted to live where she wanted to live. She wanted to associate with whom she wanted to associate. Her family wanted her money. The legal system gave them the tools to take everything from her. She was declared incompetent because she lived independently. She was imprisoned because she enjoyed her freedom. She died without ever fully escaping the guardianship that had been imposed to protect her from herself. The Upper East Side brownstone is gone, probably demolished decades ago. The White Plains mansion was never hers. Sanford Hall was torn down in 1903 to make room for luxury houses. But the laws that allowed Henrietta's imprisonment remain. The courts that stripped her rights are still stripping rights. The guardians who controlled her life have successors controlling other lives. The system that profited from her confinement is still profiting. No marker in Flushing indicates where Sanford Hall once stood. The neighborhood residents walking past the houses built on its ruins have no idea that a mansion with marble walls once held prisoners whose only crime was inconveniencing their families. Henrietta Wiley's name was forgotten for 140 years. Her story was erased along with the building that held her. But now it is told again because the patterns it reveals never stopped. They simply found new victims. Henrietta spent her inheritance freely. Her family spent her life freely. She wanted to choose how she lived. They chose how she died. The mansion with marble walls is gone. The marble walls around women's freedom are not.